My clients often ask me, what's the difference between a will and a trust? A will is a document that provides for how your property is to be dispensed when you die. A trust, on the other hand, is a document that creates a new entity, somewhat like a corporation, and this entity exists while you're alive. While you're alive, you transfer your assets into this entity, so the entity then, the trust, becomes the owner of your assets. You, however, remain the beneficiary of the assets. You have full authority and control over the assets while you're living. However, if you ever become mentally or physically disabled where you're unable to manage your assets, the trust would then provide for somebody that you respect and trust that would be able to use your assets to care for you when you were unable to manage them for yourself. Upon your passing, the trust then begins to act like a will and dictates who gets what property in the trust when you die. Trusts have a benefit that wills oftentimes don't have. Trusts can be used to plan for a disability, such as Alzheimer's, or the unforeseen circumstance, again, where you're unable to physically or mentally manage your assets. Trusts often offer privacy that a will wouldn't. With a will, it has to be probated. That means it's filed and becomes public record in the clerk's office at the courthouse. A trust, on the other hand, offers a privacy whereby only the trustee knows what the contents of the trust provide and what the assets in the trust are. Trust can also be used to shield somebody from liability because the property is no longer in the person's estate, but rather is held in trust, which again is a whole separate entity than a person's estate. That person then no longer owns the property, technically. And finally, certain trusts can offer tax savings depending on how they're drafted, depending on what type of trust it is. There's a way to draft a trust in order to avoid estate taxes and death taxes. But again, that's not all trusts, that's only certain kinds of trusts that can be drafted for that purpose. So trusts do have certain elements and values beyond that of a simple will. Maybe your situation is such where tax ramifications aren't going to affect you either way, and at that point maybe you feel a trust isn't necessary and a simple will suffice. My suggestion is sit down with an estate planning attorney, discuss the full assets in your estate and what your intent is and what your future concerns and ramifications are to determine if a trust or a will is appropriate for your particular situation.